Hi, my name is Janice Switlo. I'm also known in various parts as Sheds the Light, North Wind Woman, and Mother Grizzly Bear. I was asked to deliver a keynote address to the first conference of a community organization by the name of Secure Indigenous Land Tenure Association. And as I said, it's a community organization with, quote, focus on shared knowledge about Indigenous Allodial land title. And so, unfortunately, I had plans to appear in person, but because of COVID, I'm filming my presentation for the SILTA conference. Now, the title of my presentation is Understanding Indigenous Allodial Title, Sovereign Ownership and Land Use Laws, Canada's Absolute Title, and the Aboriginal Right of Aboriginal Title. I'll also get into discussing concepts of fee simple and other aspects of management and land and the implications for your underlying title. Now, it's important to understand that each of these terms that I've just shared with you and I will be covering in more detail, each carry legal meanings, different concepts. You know, back at the turn of the century when Indigenous nationals were speaking of, hey, that's our land, we have title to this land, it's our land. The time of treaties is important to note. It's trite to say that the law of the land is where the land is situated. So you start from the premise of Indigenous law governs their land. Now, as nations, Indigenous nations, when the Crown approached and said, I would like to be your head tenant, I would like to acquire some right to be present in your lands, then we had treaty making, actual treaty making taking place. Not to be confused with final land claim settlement agreements done under Made in BC process or Made in Nova Scotia process or special Made in Ontario process. Those are not actual treaty making. Those are governed by a domestic policy of negotiations, and those constitute domestic agreements. So we're going to cover all this, and let me get back to sort of the basis. First of all, I want to warn you, if you just Google allodial title, you'll end up getting a lot of information relating to property issues in the United States of America. So I caution you that what I'm discussing is very different from that. So allodial title there, it has a domestic concept. So don't look to examples in the United States. Also, don't look to examples, for instance, of anything that the Maori may be doing. Their treaties, different scenario. What they've been trying to do in Australia through the Mambo decision and what they set up in terms of granting land rights and things, very similar to our Section 35 doctrine, domestic doctrine of Aboriginal right of Aboriginal title. So let's get back to what I'm speaking about in terms of Indigenous Allodial title. And I'll refer you to, and I'm not going to repeat what's in there, on my YouTube channel, Switlo Sheds the Light. On the playlists, you'll see Appleseed 2.0, an audiobook. If you refer to part 1, in there I describe in full what I mean by allodial title and how your constitution is one not generated from another area. It's autochronous to your land. It means it rose up from you as the people on your land using your laws. Your constitution is extremely old, and in your constitution, in your laws, your Indigenous laws, constitution just kind of a ease of reference term to that body of your laws that govern how you govern yourselves, how you use your land. And it's important to understand that a lot of times people try to use this term, we can't own the land. What they're really trying to say is that you cannot treat the land as Western principles of property use treats their land. What you have to appreciate and understand, if you want to preserve your underlying title, your allodial title, that, yeah, you're the owners of the land. Be proud of that. This was your gift. This is your responsibility. Now, how you can deal with that land under your laws is a very different system of land use than exists in other areas of the world. And it's very different from what Canada does, what the Crown does through her governments of Canada and through her subjects and people, the Canadians and those that are not Canadian that wish to have an interest beneath the Crown's interest. So what does allodial title mean? It means, as I've just alluded to, that you don't get it from someone else. It's literally creator given. This is who you are, where you've been placed. This is your land. This is not something granted to you by another entity. Same way your Constitution is not something that has been handed to you or derived through anyone else. So none of that comes through the Crown, for instance. It was pre-existing, it continues to exist, and it will exist so long as the nations continue to survive. I'm not talking First Nations, I'm not talking Indian bands, I'm talking the entity that the Creator placed here to, with the gifts of the resources, the animals, the land, and the water, and what you're responsible to do with that. And as I said, you're the owners, but under your laws, and these are generalizing now, because I found consistency among many nations, and that is that you're always having a view for preserving and protecting the land for future generations. So it's not about me today, individual, it's a collective interest that is, yes, has layers of land use. Every system of land use has to provide in its laws who can do what when and for what purpose. And so it's important to understand that when I'm speaking of allodial title, it is the overall collective in the Big N nations, the Anishinaabe, the various actual nations with whom the Crown first engaged and ultimately entered into treaties. Now, that is, of course, then the main base foundation. Allodial title rests in the hands of the continuing nations, provided they still see themselves as alive and have not said, oh, you know, we're just mere domestic ethnic minority Indigenous Canadians or Aboriginal Canadians, just like any other immigrant that comes to the area. That's not you, but that is, of course, the structure that Canada would like you to agree to come under and accept in exchange for your sovereignty, your economic sovereignty, and of course your underlying land ownership, your allodial title. No one can take that from you, but you can certainly give it away. No individual or handful of individuals can give away your allodial title. Why? Because under your laws, again, this all hinges on your continued existence as nations, which means your laws still survive even if you're being interfered with. This is not a question of what you've been prevented from doing and what you can still do. What I'm discussing today, because that's a whole long issue, and I encourage you to review many of my episodes on Switlo Sheds the Light. But today I want to talk about the fact that still exists. This is still all here. And a handful of people, like a chief and council, cannot sign that away and have that binding on the nation. Why? Because under your laws, that's not something you can do. You can't sell the land. You own it, you protect it, and the next generation of nationals, once you're gone, are bound by your laws to do the same thing. So this is also why you should never refer to yourselves as descendants. You are the existing, walking, alive, and breathing nationals of your nations today. To say descendants is to suggest that your nations are gone and dead and you're just descended from. but you're something new. You're just an Indian band, or you're just a new artificial entity, at the very least a domestic ethnic minority. So it's important to always speak in the present tense. Those who are alive today are bound by your laws, they're bound by the treaties that you're entered into, and that means that whatever interests beneath your overriding underlying title, you need to respect as well. So let's be clear, it's the whole shebang, it's the whole ball of wax, if you will. And it all hinges on you understanding that this is not segmented out and owned by a community here and there, an Indian band or a First Nation. It has none of those attributes. It is owned by the collective, and that collective, quite frankly, extends. You got to look at the more linguistic basis to define the nations. But for example, there's a huge swath of country between the Rocky Mountains all the way to the East Coast that comprises one big tidal area. And it's a little more complicated when you get to the West Coast, but I'm not going to discuss that. So again, that's the big picture, and no one small community can say they control it or can get rid of it or sell it or encumber it. Now, having said that, communities do have rights of use. In the West Coast, you have hereditary chiefs, for instance, that control how they're responsible for enforcing laws in terms of who can use what within the houses, within the lands that layer of Indigenous law protects. Of course, there are abilities to and exists who can use what when. Again, that's part of your continuing laws. That is not, now, when we look at, for instance, Indian reserves, those are critical to allodial title. Why? Because in the treaties, these are reservations out of treaty, shortened to reserves. Reservations are typically clauses out of treaties that say, okay, I'm entering into this treaty, but I don't agree with that clause, so I'm going to do a reservation out of that clause. In this case, the reservations are areas of your land which you continue to own an underlying allodial title. But in setting up the Crown as your head tenant, you're saying that there are no permissions granted to the Crown whatsoever in those reservations out of treaty that you retain for your sole use. So these areas are areas where your full jurisdiction, your full ownership, there's no interest in the Crown created. Now, Indian Act, of course, interferes with that. Large portions of the Indian Act are unconstitutional because there is no foundation or authority for Her Majesty's governments to purport to control your governance, any aspect of your governance. And while treaties provided that the Crown will administer, what that means is basically cover the costs of your civil service when you decide to issue interests in your reserve lands, for example. So allodial title, that's the underlying title. Then we have the Crown coming and saying, gee, I'd like to continue our relationship, but not just have my traders come. You know, Crown had issued a monopoly on Rupert's Land for trade within that area called Rupert's Land. It was not a land grant, contrary to what so many people repeat and say. And so she knew that she had to get permissions from the landowners, and that's what the treaties are. And in those treaties, there's key phrases that signal that this is not a conveyance of land. So underlying title remains preserved. The underlying allodial title is not disturbed, but the Crown is coming in to say, okay, we will grant you the right to use land. Now again, law of the land, where the land is. So that also binds the Crown to your concepts of what's appropriate and how to use land. Now, Canada's title then Where there are no treaties, Canada asserts sovereignty, but where there are treaties, the Indigenous nations granted the Crown permissions to exercise partial political sovereignty over her people. So it's important then to understand how the Crown views and what the Crown calls her title. And I'm referring to the Simon and the Queen case of the Supreme Court of Canada. It's 1985 decision of November 21st, and it's reported in 1985 to Supreme Court Reports 387, and I'm referencing paragraph 37 of this decision. And here the respondent, who is Her Majesty the Queen, the respondent submits that Aboriginal title in the land covered by the treaty lies with the Crown. Now, what treaty is she referring to here? It's the Treaty of 1752. And to read that again, the Queen, her Crown, submits that absolute title in the land covered by the treaty lies with the Crown. So that's a statement of fact, and it's true. But what is absolute title? Absolute title is as against third parties. It's guaranteed title to the leasehold, which means there's no liens or attachments. Another way to think about this is the closest that individual Canadians can achieve an interest beneath the Crown's interest is an estate in fee simple, and that corresponds in practice to absolute ownership for purposes beneath the Crown. So absolute title then means that the Crown is acknowledging and has said so and submitted in the Supreme Court of Canada, and it's in the report, that she is the head tenant. And that's absolutely consistent with terms you'll find in treaties, for instance, Treaty 1 to 11, where you have the to have and to hold clause. Those are terms that indicate two things: how long is this for, and to who's the sovereign lord. In other words, beneath whom does this interest rest? So again, Indigenous nations, allodial title, owners of underlying title, overall title, grant interest to the Crown to have an absolute title, which is an interest beneath the interest, the overall whole interest held by Indigenous nations. That absolute title is as against third parties. So Spain, for instance, couldn't come and say, no, we already had a lease deal put in place, or anywhere else. This was not first rodeo. There have been many relations over the millennia that have occurred. So it's important to understand, and by the Crown's own lawyers representing in court correctly, that the Crown has absolute title. Again, that's the highest interest that could be obtained beneath the interest of the Indigenous nations. Then we have something called the Aboriginal right of Aboriginal title, which is shortened to Aboriginal title. This is the Section 35 doctrine, and I will refer you to an episode in Switlo Sheds the Light called The Plan, Section 35, and I believe that's in the first season. If not, it's in the second season. But that will show you how this Section 35 came to exist and what was done unconstitutionally in terms of trying to shape it to control and change and switch in reverse, if you will, who owns what and who has the right to do what. The Aboriginal right of Aboriginal title, that's the full technical term, because Aboriginal title is an Aboriginal right. It is not title. It is not ownership. It is a level of Aboriginal right that translates into a level of management and control. However, it's important to understand under Section 35 that all Aboriginal rights can be lawfully interfered with to the extent of not being able to be exercised at all. That includes Aboriginal title. Provided there's someone who can make some money, provided there is an overriding economic objective, providing there's national interest at stake. So a lot of people thought this Chilcotin decision was such a great deal. It's not. They basically gave up their allodial title. They accepted, by the way they proceeded in courts, they accepted that the Crown actually owns underlying title, and that the Crown was able to obtain that simply by literally planting the flag and asserting Crown sovereignty over the land. And so that's not something to celebrate at all, because it's the lowest level beneath the Crown. And the Crown at any time, her Canadian governments can infringe and interfere. So if you have for instance, a company coming from a foreign company coming in wanting to mine and remove the mines and make some money, and federal government, provincial government will benefit from taxes, then they can say it doesn't matter that you spent multiple millions of dollars going to court to prove and receive a grant of Aboriginal right, of Aboriginal title. We can step all over that and do that. Contrast that with Indigenous Allodial Title, whereby restricted limited permissions are granted to the Crown, such that only the Crown or her, acting through her Canadian government, or a Crown corporation could do things like take up and use land. Remember, all subject still to your continuing Indigenous laws. So, take for example, under Indigenous law, you can't destroy the land. You need to preserve it and protect it. Take what you need for now. And that includes a right to profit and benefit from that. But you can't destroy the land. You can't take the land away. You can't render it not usable for future generations. So that means that if a Crown corporation decided to mine, and remember, this is not transferable. These are strict permissions to the Crown, set out in treaty. This does not, because Crown, like any kind of corporation that's not a Crown corporation, is not an agent of the Crown and is not a subject of the Crown. It owes no loyalty to the Crown. It's not possible. It's an artificial entity. And most of the companies coming in wanting to do these kinds of land developments are not even incorporated in Canada. So there's a huge distinction that preserving your nationhood, your sovereignty, your allodial title, your underlying title, not giving it away, not making representations to suggest that you don't believe that you own it, then there's much that you can do to protect your lands. And contrast that with giving away all ability to control, if you will, by proceeding under domestic doctrine. So you have allodial title, you have, and with that title, you have sovereign ownership. I use the term sovereign because it's a term that in English conveys, the highest level of law, the highest ability to render and make laws and enforce laws. You have all of that, your economic sovereignty. You have land use laws that says who can do what where. So for instance, this family may be responsible for gathering and hunting in a certain area, and you would need to get their permission if you were coming into their area. And that may well be that permission cannot be withheld, but it is a part of the protocol and the respect and the significance of recognizing your laws, your land's use laws. Those are critical. So when treaties, for instance, were made, and it was agreed that Her Majesty could bring settlers in, if you will, then what that basically did is, and why the treaties 1 to 11, for example, you have this dollar amount being paid, $5, $4, to individuals. It was because, so first of all, there was no consideration given to the nations because this was not a land sale. But there is consideration given to individuals because they're having to move over and adapt their land use under Indigenous laws to make room for Her Majesty and those that she is bringing with her. It's a very different thing than suggesting that somehow the Crown became the owner. So you have then the three main concepts, if you will, to consider. So if you simply say Aboriginal title, then you're taken to mean the Section 35 Doctrine Aboriginal Right of Domestic Title, which is not even a right. It's something that is part of the domestic law that allows you to be pushed aside and off your land. Now, you have many different programs and scenarios like treaty land entitlement, settlements, specific claims, settlements. TLE is a type of specific claim, and final land claim settlements. And if you notice in there that it's structured to either hold land in fee simple or go out and buy it in fee simple from willing third-party sellers and then apply to have it added as a reserve. If the people who were putting together things like TLE and some of these things, and all the Indian lobbyists and organizations like AFN, if they were doing their job, then you would have had the Crown take care of getting the interests beneath her resolved and removed, and then that would be set aside as reserve. Why is that important? Because the settlement at that point would be, this was wrong, this is a wrongful taking, therefore it's void from the beginning. Therefore those third-party interests that may have grown on there, they get damages from the Crown to clear that title. And the Crown acknowledges that the Crown never had any rights to that, and therefore when the request to have it added to reserve, that means those lands retain their full allodial title because they become then reservations out of treaty. But by going and buying in fee simple, what you're basically acknowledging is that those are not your lands, that they were correctly taken, they could be taken, but you just owed some money for some, it shouldn't have been done that way, but still the courts, etc., will support that you get some money, you don't get the land back. So the concept of fee simple is the highest level of interest in property that a Canadian or anyone actually can obtain beneath the Crown in this part of the world. So that means you have underlying title, Indigenous nations, you have the Crown absolute title, and then individuals, companies, whatever, can purchase a lesser interest in the Crown's interest, and that's known as a fee simple, estate and fee simple. Again, there's no actual transfer of land. Canadians don't own land. They just have an interest beneath the interest of the Crown. So when you do things like a First Nation Land Management Act and pass a land code and come under that, and people are told, oh, you're exercising your jurisdiction again. Well, you're not. All you're doing is acknowledging that the Crown has underlying title, that your allodial title is gone. You're not part of a nation, and you're just being delegated some management responsibilities on your own dime. Now, sure, there's funding, but ultimately that's where it's headed. So you see how that reversal, that Indigenous nations always designed to retain ownership. The costs of dealing with the interests in land that you decide are appropriate, that costs to be covered by the Crown through her governments in Canada. Instead, you now have this reversal where the Crown says, and through all sorts of, twists and turns to try to justify this in legal concepts, because issues of the ownership of the land here are not justiciable in Canadian courts. Courts have to accept that this is Crown land, for example. So you have this switching to, Crown owns it all. It's not an allodial title. They just got it from you. They conquered you. So what are the important takeaways? One, allodial title only gets preserved if you preserve who you are. That means nations, not just communities within nations. It's not First Nations. It's not any terminology that carries legal definitions designed by domestic federal policies or federal courts, Canadian courts. Beneath that, and that's all encompassing. There are your laws that define and insist upon how that land can be dealt with. Then, continuing to be those owners, issued treaties and permissions, retaining sovereign ownership, retaining sovereign economic sovereignty in all your laws. Then Canada obtained absolute title. Absolute title meaning as against, in a higher title than against anyone else. So no one else can come forward and say, we already had to deal with these guys. Then you have this thing, that Section 35 doctrine, that, remember, only really came into effect in 1990 with the Sparrow decision and the decisions after that. And if you please, I implore you to watch, the plan, Section 35, and also to watch Appleseed 2.0 Part 1, so you understand these distinctions. The Aboriginal right of Aboriginal title is a made-up domestic thing. And to go under that voluntarily, no one can force you to do that, but to go in is to give up your entire ownership and sovereignty and nationhood. Now, for instance, there have been cases brought trying to up the annual payments to the individuals, that consideration for moving aside and allowing others to also use the land. This concept, of sharing the land, that's part of your Indigenous laws. That's why when the Crown came and said, I'd like to have a legal right to be here. I don't want to engage in war. I don't want to take this. Could never win in war, quite frankly, if they had tried to do that. Now we have this Cold War, with Her Majesty's governments acting in an outlaw nation manner, trying to confuse and coerce, and part of this strategy is how lawyers have been indoctrinated to see you only as domestic ethnic minorities, to only practice Aboriginal law, which is the Section 35 doctrine, and not to actually understand and know you as the nations you are, with the land that you own, with the laws that govern that land. All of that resting above the absolute title of the Crown. So there's questions that may result from this, and I've asked conference members to submit those to the conference coordinators so that they can send those to me, and then I will provide a written response trying to address those to the best of my ability. So it is with great pleasure that I've had this opportunity to address you. I wish I were there in person. I know that it makes a difference being able to have your questions answered as they arise. But if nothing else, please take away from this that there's a reason they keep coming for you. There's a reason these huge carrots are dangled in front of lawyers for multi-million-dollar lawsuits, in front of chief and counsel to basically starve the communities of their needs, and then offer something that's already owed in order to get signatures on agreements. But I want to rest assured that, remember, don't ever give that stuff more power than it has. Individuals do not carry the authorities under your laws to terminate you. They cannot give up your land. These are impossibilities under your laws. Focus not on the unlawful and unconstitutional nation that Canada is conducting itself as. Focus on, can we see your nation? Can we see your community? And when you speak of your community, do you always link it to the larger nation? Do you truly know who you are? That's front and foremost critical. Because as soon as you lapse into terminology like Aboriginal title and don't realize what it is you're saying when you say that, then you really do give up everything. There is no need to give up. You have the highest interests, the most valuable. If this, however, is about money, I remind you of this. Your laws are not about money. There weren't even money trade items when your laws were being developed and used and changed and adapted. This is another time of change and adaptation. It is not a time of capitulation. So I wish you all the best in your exploration of how to reinvigorate your land use laws, how to protect your actual full title from the representations and misrepresentations that are prevalent in the courts and in documents. Remember, it's not a matter of trying to run after each of those things that have been done and try to somehow undo them. Take some good words of advice were given to me. Think about it this way. When you see those things and they're stressful and they're upsetting, why not look at them and say, so what? How does that piece of paper do anything to your underlying title, to your nationhood, to who you are, to what you still have? If you're actively, even though it's hard to cast off the interferences, even though it's hard to remember some things of where you were at before the interferences began, you're never going to be able to go back there as if this never happened, but you will be able to adapt. And critical in that adaptation is not picking up language that says to the world, you're only domestic ethnic minorities. And that's all I have to say. Have a good day.